that you committed that crime, and that plea will waive and give up all the rights that I've just described for you today, except the right to have counsel, which you always have no matter what your plea. But without exception, your plea of guilty will waive and give up your right to a jury or court trial, waives and gives up your right to confront witnesses against you and to cross-examine through your attorney, waives and gives up your right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. Waives and gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. The waives gives up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. It also waives gives up your right to file an appeal on any alleged violations of your rights you feel could have happened up until this point in the case. Now, if I should sentence you at some point in the future to the maximum sentence or under other limited circumstances, you may be able to file an appeal, but that would have to be filed within 30 days of your sentencing entry being filed. And do you understand all of that?
Yes.
And are you a U.S. citizen, Ms. Stant?
Yes.
And you entered into this agreement to plead guilty voluntarily?
Yes.
Do you have any questions about the diversion process or the agreement or anything that's expected of you in that process?
No.
You understand?
Yes.
Have any questions about the charge or the possible penalty?
No.
You understand that?
Yes.
Have any questions about the plea agreement?
No.
You understand that?
Yes.
You have any questions about the constitutional rights I've explained?
No.
You understand those?
Yes.
You have any questions about the plea of guilty or the diversion program, or what will happen if you enter that plea here today?
No.
You understand?
Yes.
Is there anything you need to speak to Ms. Hapner about before we go any further?
I don't think so.
Then it's at your decision to withdraw your not guilty plea, plead guilty to the charge pursuant to the terms of the agreement that we just went over.
Yes.
Then as to the charge, which reads, that on or about period beginning July 1, 2022, continuing through November 8, 2022, and in Highland County, Ohio, that Ms. Matreka and you did either orally or in writing on oath lawfully administered or a statement made under penalty of election falsification knowingly state a falsehood as to a material matter relating to election and a proceeding before a court, tribunal, or election official, or in any manner in relation to which an oath or statement under a penalty of election is authorized by law, including a statement required for verifying or filing a declaration of candidacy, declaration of intent to be a write-in candidate, nominating petition, or other petition presented to or filed with the Secretary of State, a board of elections, or any other public office for the purpose of becoming a candidate for any elected office, including the office of a political party, for the purpose of submitting a question or issue to the electors at an election, or for the purpose of forming a political party, in violation of Section 3599.36 of the Ohio Revised Code, which is a charge of election falsification, 5th-degree felony, carrying possible prison term 26 to 12 months and fine of $2,500. How do you plead?
Guilty.
All right. The court finds that on this date, open court, defendant was advised of all of her constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. Please accept it, order filed. Court finds that there's nothing that renders this defendant ineligible to participate in the prosecuting attorney diversion program as approved by the court. And so pursuant to those standards, the court will hold defendant's plea in abeyance. There will be no finding at this time. Further proceedings are stayed, pending a report from the prosecuting attorney regarding the defendant's progress in the diversion program. She's ordered to pay the court costs pursuant to the terms of the agreement. The court finds she's paid her participation fee. She'll also pay any program fees may be rendered by by the probation department for their supervision services under this agreement. And pursuant to the statement earlier in the previous case, the court finds the arresting officer and board of elections have been notified. Count 2 is dismissed. Now that completes the case. You're no longer under pretrial supervision or house arrest. You'll be under the terms of the diversion agreement, so I'm sure Mr. Orzima's probably already got something set up for you. Just check with him before you leave. Anything further from counsel?
No, Your Honor.
All right, thank you. All right, Alyssa Young. All right, are you Alyssa Young appearing there from the Highland County Probation Department?
Yes, sir.
Case number 23CR007, State of Ohio versus Alyssa D. Young. Ms. Young is appearing by Zoom from the Probation Department. Her attorney is Sarah Barger, appearing from her office. Appearing from the prosecutor's office is Prosecuting Attorney Collins. The defendant is charged with aggravated possession of methamphetamine, a 5th-degree felony. This is a final pretrial trial set for April the 10th. Been presented with a plea of guilty form, Ms. Young, which indicates you're going to withdraw your not guilty plea, plead guilty to the charge. It's a 3-page document. I'm going to hold up page 1 first. Has your name, case number, plea of guilty form on it, and the charge. Do you recognize that form?
Yes, sir.
And on page 3, there is a line about a third of the way down that reads, I enter this plea voluntarily. Immediately below that is the signature Alyssa Young with a date of 3/16/23 next to it. Is that your signature?
Yes, Your Honor.
Is that the date you signed it?
Yes.
And when you signed it, did you understand that it was agreement to plead guilty, which means there's not going to be a trial, and the next step in your case will be a sentencing hearing?
Yes.
And before I go further, Ms. Barger, you and your client both in agreement the matter in this case can be conducted by Zoom remotely rather than in-person appearance in the courtroom.
Yes, Your Honor.
You're all right with that, Ms. Young?
Yes.
All right. And at any time, if you need to talk to Ms. Barger, since you're not sitting next to her in the courtroom, just let me know and I can put the two of you into a breakout room and you can talk without anyone else seeing you or hearing you, okay?
Okay, thank you.
And you entered into this plea voluntarily?
Yes.
All right. Now, on page 1, it says you're going to withdraw your not guilty plea, plead guilty to the charge of aggravated possession of methamphetamine under 2925.11 of the Ohio Revised Code, 5th-degree felony. Further states, you understand the maximum penalty for that could be 12 months in prison. The minimum, if a prison term is imposed, is 6 months. There could be a fine of $2,500. There could be a license suspension of 6 months to 5 years. You understand that?
Yes.
Now, are you currently on probation, community control, parole, or post-release control for a felony?
No.
Now, under the law, if you should be convicted of this offense and if you should be sentenced to prison, upon completion of that term, it is possible that the Adult Parole Authority may put you into what's called post-release control supervision for a period of up to 2 years. If they do, you'll be supervised under the conditions they set by a parole officer, and if they determine during that period of time that you have failed to comply, then they can return you to prison, even though you've served the entire prison term set by the court, for an additional period of up to 9 months for any, well, in this case, it would be half of your prison term for one or more violations. But if you commit a new felony, then in addition to whatever sentence a judge in that new case could impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively the sentence in the new case. Do you understand that?
Yes.
All right, now, under the law, I'm not required to sentence you to prison for this offense. I can put you under what's called community control or probation for a period of up to 5 years on a term set by the court. If during that period of time the probation department feels you're not compliant, they would file written notice of that with the court. There would be a hearing. You'd be entitled to have an attorney. If the outcome of that hearing was you failed to comply, then at that time the court could revoke your community control and then sentence you to prison for 6 to 12 months, fine you $2,500. You understand that?
Yes.
Well, the charge in this case alleges that on or about June 10, 2022 in this county, you did knowingly obtain, possess, or use Schedule II controlled substance with methamphetamine, violation 2925.11. So that's the charge we're talking about of aggravated possession of meth, a 5th-degree felony, with the penalties I've described. You understand what it is the state said you did, when, where, and how they alleged you did it?
Yes.
You understand the possible penalty for that offense?
Yes.
Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, the possible defense you might try to raise at trial, possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with her advice and competence in this matter?
Yes.
Are you under the influence of any kinds of drugs or alcohol at this time?
No.
I see from probation you are taking several medications, Zoloft, hydroxine, gabapentin, Flexeril, Suboxone. Do any of these medications interfere with your ability to understand what's going on in this proceeding or to comprehend things or to explain yourself?
No.
All right. Now, has anyone threatened you to make you plead guilty today?
No.
Now, the agreement states on page 2 and 2 lines that are underlined and bold, defendant shall enter plea guilty to the indictment, state and defense jointly recommend community control, the defendant be referred to drug court. That's your understanding of the agreement.
Yes.
Has anyone promised you anything other than that to get you to plead guilty here today?
No.
Now, under the law, the recommendation as to sentencing is not binding on the court. The judge is the one who makes that decision. So, if you enter a plea of guilty to the charge, I don't have to follow that recommendation. I could decide that the appropriate penalty is a sentence of prison and or fine and or license suspension or any combination. Do you understand that?
Yes, sir.
Right now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No.
Now, you have certain constitutional rights you must understand before I can accept a plea from you on this charge. First, you have a right to have an attorney. Ms. Barber is appointed to represent you, not simply to work the case out, but to provide any defense that could be available to you under the law that you'd like her to provide. So, if you decide you don't want to plead guilty, you want to defend against this charge, she'll continue to represent you, including defending you at trial if that's what you want. Do you understand that?
Yes, sir.
All right. Now, under the Constitution, you have a right to a jury trial on this charge, in which 12 people would be selected from a group of citizens that are summoned for that live in Highland County, that are summoned for jury duty on your trial date. After 12 of those folks are selected, the evidence would be presented. They'd be instructed on the law by the judge. Then that jury would have to decide by unanimous verdict, meaning all 12 would have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up your right to have a jury trial. And in that case, you would have what's called a court or bench trial. That means that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes.
Right, now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, and the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes.
All right, now under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're uncertain are going to come in voluntarily at your request, the court issues a court order, that's a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. Do you understand that?
Yes.
Under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, it's up to you. You decide not to testify. The fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because it is your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. What that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence in your own defense at all at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt, proof beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Now, under the Constitution, when you entered your plea of not guilty, you denied the allegation in the indictment and exercised all the rights that I've just described. If you change your plea today from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment, admit that it's a crime, that you committed that crime. And that plea waives, gives up all the rights that I've just described for you, except the right to have counsel. You always have a right to have counsel about your plea. But with that exception, your plea of guilty waives, gives up your right to have a jury or court trial. Waives, gives up your right to confront the witnesses against you and to cross-examine through the attorney, your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, just like the state. Waives, gives up your privilege against self-incrimination because you're the one saying you're guilty. That's what's used to find you guilty. And waives, gives up your presumption of innocence because if you say you're guilty, then the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you the maximum sentence, or I know there's certain limited circumstances you can file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Do you understand that?
Yes.
And are you a U.S. citizen?
Yes.
Now, do you have any questions about the plea, or I'm sorry, about the charge and the possible penalties?
No, not at this time, Your
You
Honor.
understand it?
Yes.
Have any questions about the plea agreement?
No.
You understand it?
Yes.
Looks like you lost power there.
Yes.
Yeah,
I
you're on
see
battery, it looks like. All right, there's back. Do you have any questions about the constitutional rights I've explained?
that. No. No.
You understand
questions.
those?
Yes.
You have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today?
Yes, I understand.
All right. Is there anything you need to speak to Ms. Berger about before we go any further?
No.
Have any questions about anything I've explained?
No, none that I can think of.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of this written plea agreement that we've just gone over?
Yes.
All right, then as to the charge, which alleges that on or about June 10, 2022 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine in violation of Section 2925.11 Ohio Revised Code, the charge of aggravated possession of methamphetamine, a fifth-degree felony, and a possible prison term between 6 to 12 months, fine of $2,500, possible license suspension for 6 months to 5 years. How do you plead?
Guilty, Your Honor.
All right, the court finds on this day in open court, the defendant was advised of all constitutional rights and made a knowing, intelligent, and voluntary waiver of the same pursuant to criminal 11. The plea is accepted, order filed. Defendant is found guilty of the charge as set forth therein. Court orders that the matter be referred to the probation department for pre-sentence investigation to include an assessment for substance use disorder and/or mental health treatment, and the case is referred to the drug court for review. The matter will be set for sentencing on April 20 at 1 o'clock. Set model continue. All right, is there anything further from counsel?
No, Your Honor.
All right, thank you.
Thank you.
My name is Jeremiah Johnson.
All right. And this is case number State of Ohio versus Jeremiah Johnson. This is a final pretrial being conducted by Zoom. And Mr. Johnson's appearing on the screen as Mark Johnson and Denowitz. I believe you're appearing from the treatment facility. Is that correct?
Yes, Your Honor.
All right. The defendant's attorney is William Armentrout, appearing from his office, and appearing from the prosecutor's office is prosecuting attorney Collins. The defendant is charged with illegal conveyance, third-degree felony, and aggravated possession of fifth-degree felony. This is a final pretrial. Trial is set for April the 10th. All right. Now, where do we stand on this case? Counsel, is discovery complete?
It is, Your Honor. I believe that there's even been a plea form that's signed. However, maybe Mr. Armitrout can speak as to its location.
No, it was never signed. That's why I asked.
Okay.
This was,
Okay.
this is one I have to get him the form, Your Honor, and I've made arrangements to do that at the treatment facility, and he can sign it and fax it back.
All right. Well, when you get that back, contact the court then, and we can get something set up either maybe tomorrow, or I know Friday is a real busy day with drug court, but maybe the first of the week. Yeah.
Okay. Jeremiah, I've got the number at the facility to call you. I tried to call back, but the line went dead, so I don't know what was up with that, but I'll try to get when we're finished here.
All right.
All right. Anything else we need to discuss?
No, Your Honor.
All right. Then Mr. Johnson, stay in touch with your attorney. He's going to get you that form, and they'll send it to the facility. They'll go over it with you, and then you can get in touch with him and discuss that, okay?
Yes, Your Honor.
All right, thank you. And I think Mr. Denowitz is scheduled also.
Yes.
All right, case number 23 CR 14, State of Ohio versus Danielle K. Denowitz. Are you Danielle K. Denowitz, appearing on the screen, Mark
Yes, sir.
Johnson and Denowitz?
Yes, sir.
All right, this is a hearing being conducted by Zoom, case number 23 CR 14, pretrial hearing. Ms. Denowitz is appearing from the treatment facility. Her attorney is Jacob Wagner, appearing from, looks like on his phone, appearing on behalf of the state's prosecuting attorney Collins. Defendant is charged with illegal conveyance and aggravated possession. This is a final pretrial, and I believe we have a trial date coming up of April 10. That's the same as the co-defendant, I believe, that was just on the screen. Now, Mr. Wagner, you wish to be heard?
Yes, sir, I apologize. We filed earlier today, Your Honor. I found out where my client was. Again, Mr. Ariajama told me, and thank you very much. She was down at TCC. In light of that, Your Honor, we did file a motion to vacate either today or the jury trial and set it for a status plea hearing. I've spoken to Danielle since then and informed her I just need to get the paperwork down to her and go over it and then get it back.
All right.
So I'm kind of the same armor trout Bill was earlier.
All right, well, let's just do this. We'll leave it as is right now, and you work on getting that to her, and if you can then get back in touch with Ms. Oyer for a hearing.
Yes, sir.
Like I said, I couldn't do something tomorrow, or if not, the first of the week, because Friday is pretty much out because of drug court.
Yes, sir.
All right, Ms. Denowitz, you stay in touch with your attorney. He'll send that paperwork down for you to review, and you need to get back in touch with him and discuss that, okay?
All right, thank you.
All right, thank you. All right. Case number 22CR255, State of Ohio versus Robert T. Dool. This is a pretrial scheduled by Zoom. Appearing from his office on behalf of the defendant is attorney William Armin. Is it Armentrout? Yes, Armentrout, William Armentrout. Appearing on behalf of the state is prosecuting attorney Collins. The defendant is not on the call. Is he at the probation department, Mr. Arjima?
No, Your Honor. He lives and works out of state. I haven't heard from him since.
Oh, yeah, he's the solar guy, isn't he? All right.
He was calling in. I haven't heard from him in a few weeks. I did just try calling, and I couldn't get through to any number.
Darman Trout, have you had a contact with Mr. Dool?
Yes, sir, the last pretrial.
Since the last pretrial?
No, sir.
I saw him then, too. All right. Well, then the court's going to issue a warrant for his arrest for failure to appear, and we'll put the matter on the inactive docket. When he's located, then we'll consider the matter further.
The number's on
All right, thank you. All right.
Did he look?
All right, this is case number 23CR15, State of Ohio versus Aaron Dale Hunt. Are you Aaron Dale Hunt?
Yes, sir.
You're appearing on the probation department screen?
Yes.
All right, this is a pretrial hearing being conducted by Zoom. Mr. Hunt's attorney is Jacob Wagner, appearing on his phone. Appearing on behalf of the state is the prosecuting attorney Collins. Defendant is charged with failure to comply and aggravated possession of methamphetamine. This is a first pretrial. Final pretrial set for the 5th of April, and trial is set for the 24th. Now, looks like the state did provide discovery. And Mr. Wagner, have you provided yours yet?
I don't believe I have, Your Honor. I'll get on it tomorrow.
All right, well, you have until the final pretrial. Are you anticipating any pretrial motions?
No, sir.
And has there been a written plea offer provided?
Yes, Your Honor.
Is your client aware of it?
Yep, and we'll probably take it, Your Honor.
Okay. All right, any other matters then to discuss at this time?
Not from
No,
the
sir.
state.
All right, then we'll see you on the 5th, if not before, Mr. Hunt. Thank you.
Thank you, Your Honor.
All right, Richard Wayne Johnson.
This is the last one.
All right, case number 23 CR 11, State of Ohio versus Richard Wayne Johnson. This is a pretrial being conducted by Zoom. And are you Samantha Pugh appearing on the screen there? Pardon me, you broke up.
Catherine Messick, Your Honor.
Catherine Messick, okay.
Appearance.
All right, I just noticed, or notice went to Miss Pugh. All right, I do recall you being in the case. All right, is your client there with you?
He's present at probation.
Oh, okay, there he is. All right. All right, you are Richard Johnson, Richard Wayne Johnson, appearing there from the probation department?
Yes, sir.
All right. And this is case 23 CR 11, State of Ohio versus Richard Wayne Johnson. This is a pre-trial being conducted by Zoom. The defendant is charged along with a co-defendant in he's charged in the first 12 counts. I believe this is a final pre-trial, and I believe we have a trial date coming up on April 10th. Now, is discovery complete on both sides?
It is from the state, Your Honor.
What about you?
I believe it is from the defense as well.
All right, you provided that in writing?
Not yet, Your Honor, but we will.
Well, then it's not complete. You have to comply by filing a written notification under the rules. So
Yes, Your Honor.
today was the deadline for that, so get it filed by tomorrow.
Yes, Your Honor.
And we don't have any of this discovery. The defense has to play by the same rules that the state does. All right. Now,
Your Honor,
are there any pretrial motions?
no.
No, Your Honor.
All right. Now, has there been a written plea agreement offer provided?
There was a written plea agreement or a plea offer provided actually a couple, maybe one or two attorneys ago, but Ms. Memsnick and I have been negotiating on this case for a week, basically, via email. We have just reached an agreement actually while I was in court with Your Honor.
Okay.
We are just going to need to have this set for a plea hearing next week.
Okay. All right. All right, Mr. Johnson, then we'll have that in person next week. So that'd be, the 10th is, so 27th would be the deadline. So that's like by Tuesday. If we got the 28th, that's actually a little bit under, but Monday or Tuesday we'll go. But otherwise, I have a 14-day rule. And so we'll need to get this on record by Tuesday. Otherwise, we need to send out jury notices. Okay. All right. Do we want to just go ahead and get a date now?
That would be great.
Let's do that. All right, as it happens, I was supposed to be in another county on the 27th, and that was case was resolved. So I have all day Monday available. Are you guys available Monday?
I'm available Monday morning, Your Honor.
All right, let's set it for 9 a.m. So, Mr. Johnson, you'll be present here in the courtroom along with your attorney for that hearing at 9 a.m. This coming Monday. All right. Any other matters we need to discuss, counsel?
No, Your Honor.
Okay.
No, Your Honor.
All right. Thank you. All right. That's every case then? All right. Thank you.